Thank you so much for joining us today, everyone. Welcome to week 26 of our Survive and Thrive webinar series that we've been running in collaboration with Gatwick Diamond Business. Joining me today is trade economist Peter Holmes, who up until very recently was a reader in economics at the University of Sussex and is involved with Interanalysis, who are members at our Falmer Centre. Rob Little, who has over 30 years experience in supply chain management and operations, and Jane Smith, who specialises in employment law and works with More Law, who are also based at the centre. So if we think about, I haven't introduced myself. My name's Daisy and I'm the community manager in Falmer at Sussex Innovation Centre. Today we're going to be talking about Brexit. So if we think back to the start of this year, it has been quite a year, Britain left the EU. I think for many people probably haven't really sort of noticed much of a difference yet, but that's because we've been in this transition period. And to be honest, my heart sank a little bit when we decided to do a webinar on Brexit, because it's not really something that I've been thinking about over the past few months, and I'm sure that's true for very many people. But luckily, we have our panel here today because nonetheless, the transition period, all the other things that have been going on, the transition period will be ending at the end of this year. So our panel are here today to give us some advice about what we should be thinking about and kind of how we can start preparing for the new year. But without further ado, I'm going to hand you over to Peter.
Right. Sorry, well, good afternoon. My name is Peter Holmes and I am trying to master the technology here. I am a trade economist, not a practical expert. So have we got the screen yet? Sorry, can I ask?
So we haven't got your screen yet. No, Peter.
I am trying to share it. Let's have a look. Anything yet? No. It should be sharing. Sorry, let's see. Share screen. No.
Oh, here we go.
Right,
Yes,
you got it.
Perfect. Got it now. Thank you.
Right, I'm very confused here. Anyway, so what I want to talk about is the sort of bigger picture and not the actual operational aspects, which Jane and Rob know much more about. As I said, I'm a trade economist with an interest in the overview. I've given evidence to various House of Commons committees at times and written quite a lot of things. And I've been working on free ports, and the front page of the Financial Times on the 3rd of August has an interesting article about some work we did on free ports. It's not completely devoid of practicalities. But what I want to, I'm not going to talk about, very difficult to find any way in which anybody might prosper, I'm afraid. So I want to talk about what's going to change on the 1st of January. And the key thing to say is nobody knows this. I was involved in a small project. It was a report for the Scottish Parliament. It's actually written by a very distinguished expert on customs procedures called Anna Jerzewska. And for this talk, I sent Anna 3 questions, and they're on the slides, and they should be and the other co-author of this was called Emily Rees. These are 2 people you really need to go to if you want detailed expertise on customs procedures and sanitary and phytosanitary savings. The first thing to say is, as I say, we just don't know. Not possible. I can't tell you how you should prepare, because something dramatic is going to change on that day, regardless of whether there's a deal or not. It is absolutely impossible to imagine that there'll be, unless the government completely changes its mind and extends somehow the transition period, everything will change on the 1st of January. We just don't know how it will change. Having a so-called deal will not, solve very real problems. A free trade agreement, which the government says it wants, with very little else, will simply eliminate tariffs on goods of British origin. That's to say, goods produced in Britain. Nothing else would solve so many things need to be dealt with. The actual level of customs duties and how you determine what type of customs arrangement each particular good is under. In particular, whether goods apparently made in Britain count as made in Britain for the purposes of what are called rules of origin. There's a big bust up going over the car industry. The EU has decided that they want only cars that have electric cars that have batteries made in Britain or the EU. Those are the only ones that would be counted for the purposes of being duty free. If we do have a deal, we will have to go along with what we agree with the EU. If we don't have a deal, our customs procedures for exporting to the EU will be whatever the EU decides they want to have. So having no deal doesn't leave us free to do whatever we want. It leaves the EU free to do whatever it wants. So we have to deal with customs procedures, customs duties. We have to have an agreement or accept unilateral decisions by the EU on technical standards. Now these, technically, we should be talking about regulations, not standards, but mandatory standards, as they're called, have to be accompanied by rules on testing procedures and certification. It's no good when people say our goods will be exactly the same as they were before Brexit. Why should the EU impose any new rules? Well, just to give you one example, the EU is changing its rules on chemicals on the 1st of January. Britain is insisting it's not going to do that. So as from the 1st of January, all our regulations in Britain will diverge automatically from the EU. How do you sell something into the EU? Well, you have to prove that despite the fact that it's made in Britain, it has been made according to EU standards. And this is where testing and certification comes in. The UK have decided to set up a completely separate system for testing chemicals to prove their safety, which gives different certificates from those which are presently issued under the EU's REACH system. And then the EU will have to decide, or we have to agree, but if we don't agree, they will decide what kind of testing procedures and paperwork to prove the testing has been properly carried out give the chemical product safe passage into the EU without it having to be tested again to make sure that it really does comply. We have to sort out what sort of documentary requirements are needed for customs procedures, for statistical measures. We need to work out how VAT is going to be handled. We need to work out the status of lorry drivers. It's very important. We need to work out the status of lorries. Will UK trucks be allowed to pick up goods on a return journey? Will the lorry drivers be allowed to work for more than a certain number of days? The whole point is all of these things will completely affect our trade in a uniquely negative way. One thing we can say with confidence is that so-called new trade deals will not create additional opportunities. They will simply prevent the removal of some where we do have a trade deal under the EU and we're walking away from it now. I've been talking briefly about technical standards, but if I was talking to one of the companies in Sync that makes medical testing equipment, what they're going to have to do is register with a Dutch testing and certification standards body, so that in order to sell things into the EU after the end of the transition period, an inspector can come over from Holland, do a test on a British product to confirm that it is in fact in compliance with the EU rules. That will have to be issued, there'll have to be a paper issued. The goods will then be trucked across with this piece of paper. They will potentially have to be stopped. And it doesn't actually matter if your goods have all got the right paperwork. If the lorry in front of you doesn't have the right paperwork, you're in trouble. But of course, you're going to be checked at the Kent. You first of all have to queue at the Kent border while the British check that they think your paperwork is okay to get your lorry into France. But the French will then decide themselves what percentage of goods that as they come through, say they've got the right paperwork, will actually have to take the paperwork to an office to be checked. And then how many of those will need to be randomly checked. The other thing, which is very obscure, is the so-called rules of origin thing. Even a free trade agreement, which gives 0 tariffs for British made goods, requires rules to define what is a British made good. 0 tariffs on cars will mean that you won't pay tariffs on your cars if they have 55% UK, or almost certainly they'll allow parts and components made in the EU to be sold back. But then how do you prove that this car, which when you look at it just looks like any other car, how do you prove that the UK content really is enough to be qualified for free entry into the EU? Does it have Japanese goods which will disqualify Japanese contents, which will have which will be eligible for tariffs? So tariffs themselves are actually very low. It's going to be not very easy to get exemption from the tariffs, but then all the technical standard barriers will remain in place, and we'll need something much more complicated than an ordinary free trade agreement. As I said, things like health. If you want to go and do business in Europe with no free trade agreement, people may not be allowed to go and give lectures. And lawyers, I mean, I'm sure Jane will talk about this. Can a UK lawyer who knows about EU law give advice to anybody located in the EU? So as I said, we just don't know what the rules are going to be. Now, I've included here the title of a report which might be of interest to you. This was written by Anna Jezewska, a very distinguished customs consultant, and Emily Rees and I made a small contribution to it. So you might want to look at that. So we just don't know, at least I don't know. So I emailed Anna and said, you know, can you answer these three questions for our friends in Sync? The first one is there enough information available for a firm to know what to do? Can you prepare? And her answer is no, there isn't. We're still missing the crucial information on how things work, e.g. how customs advance payments work and so on. We're also missing good, clear guidance on what we already know. For example, not all businesses are clear on what the liabilities that they bear are. So we know a little bit about the way in which if you're selling goods, the safety standards, you'll have to appoint an agent in the EU to be legally responsible for the safety of your goods as they come in. But that's really quite a complicated business. How does it actually happen? So basically, firms do not have enough information about the procedures, and we don't know what the whole basis of it is going to be. 2 months before before the end of the transition period, we don't know whether we'll have a free trade agreement or not, and we do not know what the procedures that free trade agreement will have, and we don't know what unilateral measures the EU will impose on the UK to allow goods in. Next question, what is the best available source of information, apart from a certain report to the Scottish Parliament there? Again, on the right, you have Anna's answer. Unfortunately, the kind of guidance you have is only the published documents, which are inadequate. The EU itself and various member states have given quite good advice on what they will be requiring for export into the EU, but you'll have to go to their websites. But supposing you don't really know what where to look for these things, who would you go to? Do you go to your lawyer? I've suggested they should go to Anna Jezewska, if they can afford her. Should it be an accountant? Will the accountants know? What about a customs agent? Well, her advice is you should go to a customs specialist. Now, Rob will be able to say much more about what the exact nature of his work is, but there are customs brokers, the chambers of commerce have a lot of help, but they don't know what is going to be imposed on them. They will learn pretty fast, but we basically don't know what kind of documents are going to be needed, what kind of evidence you'll have to produce to get the document which you'll need, how many checks there are going to be at the border. And that is essentially up to the EU if we don't have a deal. So we just don't know where we are. And that's it, really. Have a nice Trump Day.
Thank you, Peter. So just a bit more uncertainty for us all.
Absolutely uncertainty.
In such uncertain times.
Yes.
Thank you, that was really helpful. And Felix has just popped the link into the chat there for anyone who's interested in
and the slides
in this report.
If you could
yes, and I'll be sharing it from the slides afterwards as well. Thank you. Now, Rob, over to you.
Okay.
Thank you.
Thank you very much.
Also, if anyone's got any questions, sorry, I should add, any questions for Peter, do please pop those in the Q&A and we'll come to those later.
So hopefully my screen will be popping up soon. Has it appeared already? Cool, excellent. Myself and Jane obviously haven't had our book allocation delivered yet, so we've got slightly more boring walls than everybody else, so I do apologise. Hi, my name's Rob Little. I've had the privilege of working in sort of supply chain operations and project management for well over 30 years now. I've worked in the UK, Europe, and much further afield as well. I'm not a Brexit expert or a trade advisor. I'm just acutely aware of the impact from my clients that I work with, that in 58 days the world potentially changes, and it's a very fast moving picture. Hopefully it's not too much sucking eggs and things, but just some things to make people think. So slow down. Interestingly, we all hate change, and the COVID pandemic, I think, has given us some quite interesting practice of having a catastrophic change that's unplanned. So that's quite an interesting stress that we've had. And I think, as Peter alluded to as well, is that it's not just us leaving the EU, is that it will impact everybody else that trades with us through or via the EU. So it's a ripple effect. So different people will think, well, I export, import worldwide, so I'm already used to this sort of complexity. There'll be people that import, export via the EU or through the EU, and they won't have any of the skills or background of what exporting used to entail. And then there's other people that don't import or export and think they'll be fine, but actually you may well get hit by that ripple effect. As I think we will all confirm, there is absolutely no certainty out there. And it's definitely whitewater times, that we're all going in the same direction, but we're not quite in control. There is guidance out there, but there are no answers yet. The only kind of legitimate source that we have is the kind of the Gov UK transition thing, but maybe that's more politics than answers. Of course, we can only cope with three words nowadays with how we do with things. So their thing is check, change, and go. My view is check, check, check again. Oh, too late. It's gone, because that's kind of the scenario that we're in. I work in manufacturing and distribution, and it takes a while for people to get back up to speed on these things. Again, a good source of information, even though there's not such a thing as a fact yet, is Made UK. It's a membership organisation, but they're pretty on the ball. They have a Brexit toolkit similar to the UK Gov one, but again, I think we just need to be well aware that there aren't any facts It is just conjecture. So I think reinforcing what Peter said is go to your trade association, go to people that are trusted, your chambers. They will not be able to give you answers, but they will be a kind of a place to go. So if you do use FedEx for your shipping at the moment, then they may well be a resource. But I think starting with your trade association that's most aligned to your business is probably a good place if you need to start talking to people. There isn't such a thing as a concise guide, so everything, there's too many variables. So the closer you can get to a similar business means a lot less sort of questions and paperwork and confusion. So I thought I'd just highlight some of the things that if you're a manufacturer, distributor, and how it could impact you if you're moving goods around. Generally, the documentation you do is exporting, because if you're importing, you'll be the recipient of some of these. So there's all brand new words, maybe for quite a few organisations, such as commercial invoices and custom declarations, certificates of origin, dangerous goods notes. Of course, we're all used to those for exporting outside of Europe, if you do that already, but all these standards haven't necessarily been defined now. 0% on VAT, export licenses, and of course the big one, which is tariffs, which has a big impact potentially on the goods you could be buying or selling. There's some simple things that you can do. You can have an ORI number, which only takes about a week to get. It's not a big thing, but that gives you some sort of just basic sort of presence in the sort of the shipping world. There's other things you can get as an authorized economic operator, which is a more complicated process. And there's other acronyms that are floating around, which is the deferred approval, your DAN number, which again means that you don't necessarily have to pay all your monies up front with tariffs and things, and there's deferred payments. Again, if you're moving stuff, who is your haulier, courier, agent at the moment? Is there any guidance or reassurance they can give you? So that's part of your sort of physical moving goods. The next element is to perhaps try and understand how complex your supply chain is. You might not be importing or exporting, but your suppliers and your customers may well be. So do you want to be talking to your suppliers to see how well they are prepared? How far does this ripple effects go through? Again, you might be buying a finished component or a finished product, but the elements that have gone into that, you aren't in control of. So again, it's trying to understand where you are. Again, it's not about resolving all of these issues. As we've had with the COVID pandemic, you can't plan and resolve every issue, but being aware is a powerful place. So it's about reassurance, and kind of with my consultancy and project work is gaps are okay. You don't have to solve everything, but you just need to understand how big your gaps potentially are. Again, you don't need to plan for everything. It's just giving yourself enough time that when that swerve ball arrives, you've got time to solve it because the rest of the plan is working. I think one of the other things we need to understand is that all of these changes will have a knock-on effect in time and cost. So we need to be well aware, both for our own businesses, but also our suppliers and customers, of how things might change. The next element is about how resilient your supply chain is. I think even the conservative person will believe that there is going to be, at least in the short term, some disruption. We live on an island, we're all in the same boat. Well, with our limited border crossings, we're all going through the same places. So even if we get all our ducks in a line, we only need to get stuck behind the lorry that Peter said, and we're impacted. So some of the things that you can look at now are how can you mitigate some of those risks. Can you increase your stock holding to protect yourself? Can you find alternative sources? So if one route dries up, you can go through the other way. Is the benefit worth the cost? So it's not always just a natural decision that you surround yourself in stock and go bust that way. Actually, are there some strategic moves that you can do now that will help you? Just a simple thing. Most businesses do their stock check at the end of the year for the financial records and things. That's going to be too late this year. If you find you've got a stock shortage at your stock check at Christmas, it's too late. So maybe do some of your stock checking now. If you've got any stock discrepancies, this is the time to be placing your orders to make sure that you can get perhaps the goods in before all of this happens, rather than finding that problem when you hit the perfect storm. And on top of that resilience, of course, we also have the staffing issue because of residency and EU nationals, which again hasn't been defined. Just on the last slide, really, COVID for the businesses I've been supporting has been a horrifically great practice run on the disruptions you can face. So we've had some practice of trying to be resilient and disrupted supply chains. So it's not going to come in cold on this one. Just hoping that the COVID side of things is dying down, and we don't actually have a multiplier effect of massive disrupted supply chains because people can't get componentry or materials because of COVID, which then knocks on with people not being experienced or not up to speed or prepared because of the Brexit changes. So I have to say, for most manufacturing and distribution organisations, it's a pretty nerve-wracking time, because the government's telling you to prepare, but actually we're not really sure what we're preparing for, and each preparation and each impact is a cost, both in time and money potentially, and that's very hard, especially when companies are particularly stressed at the moment financially because of the COVID side of things. So kind of as a reinforcing thing is that we can't pass the exam at the moment because the document hasn't even been written and we haven't even been told what the subject is. We can't really even revise. We can prepare ourselves, but again, not sure what we're doing. So I think for me, that it's just being wise, just being aware that we don't know what we're going into. Try and tick the boxes of what we can control, protect yourself where it is cost and time viable, and just give yourself enough of a gap so when the swerve balls hit, you've got the time and resources to try and minimize and mitigate as much as you possibly can. But that really is the shock at the moment that is the Brexit countdown. I think we're on 58 days before the world changes for many people, and it is a ripple effect. It will affect pretty well all businesses in some way because of supply chains are so global and complex now. So that's my whistle-stop tour of where we are with Brexit. Thank
you, Rob. I love that. Be wise. You all need to try and be wise.
Just be wise. That's all we can be at the moment.
Yeah, that's great. Thank you so much. And if anyone has any questions for Rob, I've got a comment from Peter. Peter totally agrees with you. That's good. We'll go. But for now, I'm going to pass over to Jane, who's going to talk to us about the employment law side of things with regards to Brexit.
Good afternoon, everyone. Can you see my slides? They nice and green there. Thank you very much, everyone. I think the employment side, so employing EU nationals post-Brexit is maybe slightly more certain than the issues that Rob and Peter have been talking to you about. So hopefully I'll be able to guide you through a little bit. more as to what to expect. But totally agree, prepare is the key message, I think, with everything on Brexit. I thought probably the first thing to do would be useful to remind you about what an employer's obligations are in relation to employing overseas nationals in any event. An employer has a duty to prevent illegal working, and it's unlawful for an employer to employ someone who doesn't have the right to live and appropriate permissions to work in the UK. Employers face potentially severe criminal and civil sanctions, including very high fines if they fail to prevent illegal working. And obviously that's something going to have to be more aware of going forward with EU nationals. Oops, my slide's not working. There we go. So where are we now in terms of Brexit? With Brexit in mind, there are 3 million EU nationals currently living and working in the EU, in the UK approximately. And as we know, the UK officially left the EU at 11 o'clock on the 31st of January, and we've entered into this implementation period, which ends on the 31st of December. The ongoing rights of EU citizens in the UK and the reciprocal rights of British citizens to live and work within the EU were one of the key issues actually discussed during the Brexit negotiations. The very sort of approach of what's going to happen is that free movement will end on the 31st of December. And anyone arriving from the EU after that date will need to apply for a work visa of some kind. And any EU nationals that are already living and working in the UK, as at the 31st of December, will need to apply for some kind of settled status, but they won't need a visa to continue to work. I thought it might be helpful just to briefly outline the visa process. So for anyone that needs to apply for a work visa, you apply under the UK immigration points-based system. It's a fairly complex system, as you would imagine. There are different types of visa that you can apply for, and they all have slightly different criteria for qualification. But broadly speaking, the visa is usually applied for, usually by the employer when the employee is still overseas, so they're not yet here. The employee has to already have had a proper formal job offer made to them by the employer, and that employer must be a licensed sponsor, which means that they must hold a valid certificate of sponsorship. And it takes around 8 weeks in usual times to apply for a sponsorship license. The visa can be applied for no more than 3 months before the role is due to start, and at least 4 weeks before it's due to start. But I would say at the moment, you can imagine what the immigration system must be like. They've got COVID backlogs, they've got Brexit influxes, so it's going to be an absolute mess, I would imagine. So back to what's going to happen. On the 1st of January. I've looked, been looking again as Peter and Rob, you know, what can we do? What can we do? What do we know? What can we do to prepare? We've got a little bit more certainty, as I said, because the implementation period up to the 31st of December was supposed to intended to sort of stop a cliff edge position where everybody had a period of time to implement some measures gradually. But unfortunately with COVID, everyone's been so busy doing everything else that they haven't really had time to worry about these things. And from my experience, quite a lot of employers are delaying preparing for any changes, as they wrongly presume that the issue with citizens' rights to live and work are kind of wrapped up with the UK-EU trade negotiations, and that's not the case. These rights were agreed earlier in the withdrawal agreement, so we kind of know what's going to happen. We're just waiting for the final details, but we can at least, in terms of people working in the either British employees working in the EU going forward, or EU citizens coming here, we can with some certainty explain roughly what's going to happen. So as I said, the baseline issue is come the 1st of January, an EU citizen living and working in the UK will, if they're already here, they'll need to apply for either settled or part settled status, or if they come in after the 31st of December, they'll need to apply for a work visa first. So what's settled status? EU citizens who have resided lawfully in the UK for 5 years by the 31st of December can apply for settled status free of charge to stay indefinitely in the UK under the EU settlement scheme, or the EUSS. They'll be free to live, work and study in the UK. They'll have access to public funds and services, and they can then go on and apply for British citizenship when eligible. EU citizens that currently have permanent resident documentation still need to apply for settled status, because indefinite leave to remain is not automatically given to them. And I think that's one thing that quite a lot of people are finding difficult to accept and or have knowledge of. So you could have people that have lived here for the majority of their lives that are French or German, who suddenly have to apply for settled status, but they need to do it. There's also pre-settled status, which is for EU citizens who are resident on the 31st of December this year, but they haven't been here for 5 years. They apply under the same process for pre-settled status, which will give them the same rights to live, work and study here. When they hit their 5 years, they can then apply for the full settled status. Sorry, I meant to say there's a deadline for applying for both settled and pre-settled status of the 30th of June 2021. If your EU national hasn't applied by that date, they will technically become an illegal immigrant, and they'll be they'll be subject to removal from the UK as an illegal immigrant. So it's quite important that they do apply and in time. With regards to British and Irish nationals, British citizens living and working in the EU will be subject to a very similar situation to those coming to work in the UK from the EU. But you'll need to look at which country they're going to work in, because the system will vary from country to country and what permissions they need. With Irish citizens, obviously they are part of the EU still. They do not have to apply for settled status to live and work here going forward. That's an agreement. I think it was the Good Friday Agreement agreed for them to do that. So it's kind of a little quirk, and some people are finding it useful to apply for Irish citizenship as a way to get past the settled status or work permits going forward, if they're eligible to apply for citizenship in Ireland. I then thought it might be quite useful to come up with a little plan of action. So I've got a 3-step Brexit plan for employers. Step 1 is to understand the new rules and keep your employees up to date. This will then ensure that you meet your legal obligations, and it will help you promote stability within your workforce, and also manage any uncertainty with arrangements from the 1st of January. So just some suggestions that I've suggested that you might like to look at. Either take advice or undertake some training as necessary to understand that you fully understand how the rules will work going forward. Provide some kind of update resource for your employees to keep track of Brexit developments. This could be an intranet or somewhere on your website. There's another point further down as well, which is consider facilitating an information sharing forum. You could do these all as one thing. It could be done on something like Slack to enable accurate immigration advice to be circulated. The only thing that you've got to make sure that somebody's monitoring it so that you haven't got any false information circulating. Provide information to employees as to how to safeguard their immigration status. So for example, if you know that you have EU nationals working already within your organisation, you could have a chat with them to see how they're feeling about Brexit and see if they need any assistance in things like applying for settled status going forward. It's a really good idea for you to have a clear Brexit strategy, especially if you've got EU nationals that work within your workforce, or if you do trade with the EU. So you have an announcement to staff as to how things will work going forward as best you can. And understand that the basic principles will also apply to your British employees working in the EU, albeit that they'll need different visa requirements will be applicable to them. So for example, whereas before it might have been quite easy for someone in your workforce to go and nip over to the EU on a plane and just go and work somewhere for a couple of months, that's going to be really difficult for you to do going forward, and you're going to need to manage that, and you're going to need to find out exactly what's required to send that British citizen abroad, and plan in good time for them going. Step 2 is a review and implementation step for your Brexit plan for employers. It's key to understand what measures your business might need to put in place before the 1st of January, as we've said. And a good thing to do is to really look carefully at your current reliance on EU national employees. Do you need them? If you do still need them, and it's going to be costly and difficult to continue to employ people going forward, not so much if they're already here and they can apply for settled status, but for new people coming over after the 1st of January. And I'm going to give you some figures as to the sort of costs involved. But if you do still need to employ EU nationals going forward, you're going to need to have a sponsorship license. Again, as I said, it takes around 8 weeks in normal times to apply for one of those. At the moment, it's likely to take a lot longer, so to get your applications in sooner rather than later. Sorry, skipped ahead there. If you've already got a sponsorship license, you should consider that license. Check that it covers the type of employees that you need it to cover going forward. And make sure that you understand and can meet your sponsorship duties that are placed on you under that license, which are things like making sure that you can identify and carry out the correct right to work checks, that you report any changes in your business or sponsored workforce to the Home Office, and that you're prepared for a spot check Home Office audit at any point in time. Again, audit your EU national employees, so you've got really clear idea of who they are, whether they have a limited or a permanent role which is likely to see them employed after the 31st of December. Look at their current immigration status and whether you're going to need to make any further checks after the 1st of January or beyond. And again, can you assist them with protecting their status? If you're considering taking on any new employees from the EU anytime in the next few months, would it be possible for you to bring their start date forward so they arrive in the UK before the 31st of December? That will stop them needing a work visa, and it may be that they can apply for the pre-settled status. And just look at your history historically as a business. Do you rely on taking on EU nationals, as I've said? And sort of, if you do, you're going to need to very much keep up to date with developments which are likely to be fast moving and quickly implemented in the next couple of months. And think about whether you could relocate any of your employees in or out of the UK. If you need to, plan for it now ahead of time. And the final step is look at future-proofing your business for immigration. You could consider putting a strategy in place, which are various steps to take prior to the 1st of January, but which will continue on an ongoing basis, which will protect you in relation to business immigration. Such things as I've suggested here as having robust HR checks to establish the immigration status of all employees, and I must stress it has to be all employees, not some employees, because then you open yourself up to potential claims for discrimination. Look at things like your recruitment process. Do you need to lengthen these to take into account the time it will take EU nationals to apply for visas? As I said, after the 1st of January, all applications will usually be when the employee's still overseas, and depending on their role, it may be that you've got to put a sponsorship license in place, and the employee may well have to prove English language competency as one of the key parts of some visa requirements. And again, things like that can take forever, especially when they're being carried out abroad. So you need to sort of take into account things like that and factor that into when people can actually start working for you. In terms of the cost, huge costs for employing EU nationals going forward through a visa programme. You have to look at things like the sponsorship license itself costs money to apply for. The visas individually have a fee associated, and you might have to pay immigration skills charges, and also immigration health surcharges. I've given some brief figures that I've found, but this is only a rough idea. It's expected that a visa application for a small business for a 12-month visa will carry a fee of around £1,800 per application. And an immigration skills charge would then be around £5,000 per employee. And an immigration health surcharge is around £625 a year. That the surcharge gives the individual access to our NHS system. But again, the charges vary massively depending on the type of visa that you're applying for and the individual circumstances. And then just the last point to note is from the 1st of July, employers are going to have an additional sort of check when you're taking on EU or Swiss nationals, but this doesn't apply to Irish nationals who are exempt. You will need to carry out an online digital check as to the employee's work status under the EU settlement scheme. That's about it. I hope this helps. I appreciate it's quite a minefield. There's lots of information out there. please start thinking about employing nationals and sending your British workers overseas sort of from the 1st of January. I'm hoping that the slides, which I think Daisy's going to circulate at the end, can be like a little sort of fact check for you to go through and just remind yourself of some key points. But we're here if you want to have a chat with us. Please get in contact with me. My contact details are on the slides. I'll be happy to help. Any questions?
Yeah, any questions?
Probably ran over a bit. So it's a bit of a dry subject, immigration.
That's really, really helpful there. I had no idea the costs that would be involved. Surely for small businesses, that's going to be a massive deterrent.
It's massively prohibitive, isn't it?
Yeah. Oh, one from Sally talking about the cost involved. Would you be able to repeat the fees?
Yeah, sure. So these are just some standard fees that I've picked up. They might not be exactly applicable to your circumstance, so you'd need to check. But the fees that I've got written down for an average application. So your sponsorship license, I haven't actually got a figure for how much that will be. But your visa application is around £1,800 per application for a 12-month visa for a small company. Then you have an immigration skills charge on top of that of around £5,000 per employee. And then the surcharge, which is the NHS access, is around £625 per employee. That's where the employee is on a visa that lasts longer than 6 months. My understanding is under 6 months, they don't have to pay the surcharge.
It's incredible, isn't it?
Isn't it? And if you employ a few people, it'll just cost.
And presumably that's just applying, the application might not even be successful and you've still spent.
Yeah, I think so. I think that's right. I don't think you get it back. So I think you have to be fairly confident that they're going to meet all the criteria before you apply. So
that sounds like a point to make. Thank you. And if anyone else has got any other questions for our panel, for any of the panel, please do pop those in the Q&A. I am now going to very quickly promote my colleague Helena to the panel. None of us at Sussex Innovation are Brexit experts, which is why we brought this panel together. So we cannot help businesses with any Brexit issues, but we have been supporting businesses in many other ways, particularly through COVID. So I'm just going to let Helena join us now to talk to us a little bit more about that.
Hi, yeah, I just wanted to join and say I've been scribbling a lot of notes as you've been talking, going, all these things that we have to think about that we were very, very front of mind before COVID hit us. And, you know, it's coming up on us quickly now, isn't it? So it's brilliant. Thank you all so much for your very different perspectives from your very different sectors that you deal with in terms of the multifaceted ways that obviously Brexit's going to be the next thing that businesses are going to be needing to deal with, really. So we are starting to, you know, refocus a lot more on having some of our time and energy focused on this kind of area. The people here have obviously got a lot of skills to help anybody on the call who wants a little bit more advice, whether that's with exporting, whether that's with HR related things, whether that's with operational issues. But do get in touch if there's anything that we can do to help you now, whether that's because of how you're having to deal with, you know, the latest government announcement on Saturday and extended home working for your teams, or whether that's things that you know you've got coming up as issues with Brexit. You know, we're here for you, and we're really fortunate to be part of this amazing network with people like this around us who can help you with those elements of challenge in your business. So I just want to say thank you, really. And I think Peter wanted to say just a closing word.
Well, yes, I don't want to be too negative. I don't mind being negative about Brexit, but I don't want to be totally negative about the help that we can give, because I mean, you see what Rob knows. I'm sure he'll remind you of what he does. Intra-analysis located in Sync. I mean, our expertise has been on the evolution of Brexit. So what we know about is the way the tariffs are being set, the general framework of the rules on technical standards and so on, and data and so on. So we are very ready to help people who need a slightly bigger picture assistance. And we're not physically in sync, as you see at the moment. There's not enough space to have all these books in the entire sync building, but we are, with Michael Laffey, who sort of runs everything for us, we are willing to offer help on, as I said, the policy and the more statistical and the rule and the legal bit that's got nothing to do with all the things that Jane knows about. And if I could just say, emphasize something Jane said. Rob and I have been saying how difficult it is to know what's going on, and Jane was able to say exactly what the rules are on employment. And as she said, but it's worth repeating in case people hadn't quite grasped this, the employment and citizens' rights thing was fairly extensively settled in the withdrawal agreement. The trade in goods and services, and we didn't say much about services, that was laid down rather very, very loosely in the withdrawal agreement. And there was a path to where we were going in the so-called political declaration. The government in January or February decided basically to tear up the political declaration and started with its own view of what the rules should be. So that's why we know where we are on employment. We don't know on goods, and again, services are very important, because this was not settled in the withdrawal agreement, and the government basically went back to basics, refusing to negotiate, as it said it would, a so-called level playing field agreement. But we will share our ignorance with you.
Thank you, Peter. We've actually got a couple of last-minute questions coming. I think we've got 3 minutes. Rob, I know you have to go bang on too. Hopefully, if everyone else could spare a couple of minutes. We had a question from an anonymous attendee asking about what happens if you're a freelancer. I'm assuming that's regarding kind of employment if you're a freelancer.
Yes, good question. I think it depends whether it goes into services, but I think generally speaking, you'd have to have a look and see what you're providing going forward, and whether you actually need a permit. If you're working, you probably will need one of some description, and there's different tiers and different visas to apply for. So if you get stuck, let me know and I'll have a look through and see if I can help.
Could I just throw a whole thing there, because there's the trade law dimension to that, because where the EU and the UK have scheduled, as they say, a particular the delivery of a service through what's called the temporary movement of natural persons, there is a route to move in as a self-employed person, even if you don't have the right to work as an employee. So you look at the WTO angle as well as the actual employment law angle where non-employed people are concerned. I think that's right, isn't it?
I will nod.
Supply chain nods.
One last question as well, and this one's from Scott. This one's around VAT. In lots of commercial agreements, there is a provision for recovery of VAT, and they've seen the rights of suppliers to withhold payments. He's been getting lots of questions about this. How might UK companies mitigate it?
From a supply chain side, I'm no finance guy, and I know that the VAT Europe side of things, depending on how much you trade to different countries, has always been quite complex. I personally, honestly don't have an answer to it. I understand it's very complicated, but that always sort of falls down to the financial sides of things. So yeah, I would be wrong to answer any comment either way on that. All I know is it was complicated in the past, actually, even trading within the EU with VAT, and now it changes. And yeah, zero VAT on stuff. I don't know how that would change agreements. So sorry, Scott, I'm not much use at all, I would suggest.
Thank you, Thank you. And final parting note, I will just, before we lead on this, I think this is a good last question for the panel. I will just mention that we will be back in 2 weeks for another Survive and Thrive webinar, which I think Felix is going to share the link in the chat for that one. Topic, a completely different topic. In a couple of weeks, we're going to be looking at creative content. Oh, and Helena has something else.
There's a couple of questions lurking in the Q&A as well, actually. I don't know if we've got time, and obviously people need to go jump off, but Sally Hardy's got a couple of questions there. She's obviously running a larger organisation, or responded to one of your questions, Sally, but on VAT, will we need to fix fiscal representation in countries in which we work?
In which we work or trade, the trade value, again, I'm not sure how that changes, because you'd have to be VAT registered in the countries if you hit their VAT limits in the past. Again, if we're fully exporting now, depending on what's agreed, maybe that necessity goes away, because but again, it's a financial question rather than a supply chain question. To me, I wouldn't know the answer, but I don't think it has been answered yet.
Sally, we'll take that as a question and we'll find somebody who you can help you with it, yeah? If there is somebody who can help you with it yet, which may not be. But we'll keep an eye on it for you. And then there's one here from Michael Laffey on a scale of
this is the final parting question, last one. That was a good one to end on. You go for it, Helena.
On a scale of -10 to +10, how would panelists score Brexit? I'm not quite sure exactly what you're asking, Michael, taking into account your particular expertise and what you hear through networks. So is that, Michael, are you asking what you think the degree of the challenge is, or the degree of what hasn't already been answered in, the uncertainty? I'm not entirely sure. If you can drop me a note in the chat, otherwise we might have to leave that one.
I'm happy to answer quickly.
Yep.
It has to be close to -10 in the sense of the economics. Firstly, people are not doing this for economic benefit. If they value the symbols of independence, that's fine, but the economics are all negative. And secondly, I think leaving the final decision until 58 days before the end of the transition period, I think that speaks for itself.
Yeah. So I've got a -10. Rob?
Yeah, for me, operationally, it takes time to turn big ships, if you see what I mean. And I think whatever the rights and wrongs of Brexit are, and I've got my own personal views, but it's the leaving it so late is that change is painful and takes time, and it's very disingenuous for the government to advertise that it's sort of prepare, check and go. Actually, you can't do that. You can't do it in a year when you make things complex, and changing something like this and making people believe that it will all be fine on January the 1st is a complete fallacy. So personally, -10 for leaving, but also kind of I'd put -50 on for being able to actually piss up in a brewery. Sorry. Because it's going to really hurt businesses, and they are suffering. Most businesses are suffering because of COVID, and then you're just going to layer this on top. So I think it's going to be very painful.
And Jane?
I agree. The only thing is, obviously, there is a way forward on the employment side. So at least we've got a framework we can follow, and it's costly and it's a pain in the backside. But it is negotiable if you plan for it, whereas the other things are not. But I think, yeah, the impact generally to our clients and businesses is just going to be horrific.
And on that cheery note,
the 3 -10s, hopefully.
So Sally,
really good practical advice.
But, you know, I think it's good for us to be refocusing on the challenge, as Rob says, in terms of like, you know, let's do as much as we can now and not leave it later, because we've all been focusing on COVID. So, yeah, and so I think the information that we have is better to be armed with what we can be armed with and start working towards it, even if it's not ideal. So, great. Thank you so much.
Thanks all for joining us.
Join our upbeat session.
See you in a couple of weeks.
Thank you very much for inviting me.
Thank you.
Thank you.
Bye-bye.